So good morning, everyone. I think we'll get started. Thank you very much indeed for taking the time to attend this webinar. My name's Joanna Bogue-Thompson. I'm one of the partners in our Media and Technology team. And on behalf of Shepherd and Wedderburn, I'd like to welcome you to our data protection update this morning. And believe it or not, GDPR is now 5 years old. And looking back to 2018, there's been a lot of development in data protection law, and it continues really to develop at pace. And our last webinar was in November 2022. So our plan today is to bring you up to date on what's been happening in the world of data protection in the last 6 months or so. We've got 4 speakers today. We've got a range of topics to rattle through. So our speakers will introduce themselves. And without further ado, let me hand you over to our first speaker, Ashley McLean.
Thanks, Joanna. Good morning, everyone. I'm Ashley McLean, Legal Director in the Media and Technology team. I hope everyone's had their morning hit of caffeine because a lot of things have been happening on transfers of personal data to the US recently. And I have about 10 minutes or so to explain those developments to you and to tell you what you need to know. So specifically, I'll discuss the recent ruling by the Irish Data Protection Commission on the transfer of personal data by Meta Ireland from the EU to the US. And the potential implications of that decision. It's a juicy one with the largest fine under GDPR to date. I'll also give you an update on the current state of the EU and US negotiations on data transfers from the EU to the US. So could we have easier transfers of data from the EU to the US and from the EU to the US and from the UK to the US by the end of 2023? My goodness, I hope so. Transfers of personal data from the EU to the US has been a hot topic since Schrems 1 in 2015, which I'll very briefly explain shortly. We've been seeing in Europe, though not in the UK courts, a number of examples of contractual arrangements being challenged where they involve transfers of personal data from the EU to the US. It seems that many EU supervisory authorities are taking a hard line on transfers of data from the EU to the US and favouring data localisation in the EU. As a result, for a while now, we've been seeing increased pressure on businesses from their EU customers about keeping data in the EU, and the Meta decision will not help that. So why are transfers of personal data from the EU to the US so problematic? Well, the EU GDPR and its predecessor create a framework for ensuring personal data is protected once it is moved outside the EU. And EU GDPR sets out bases on which international transfers of personal data can be made. One of these is an adequacy approval from the European Commission, which means that it is accepted that local data protection laws or a mechanism are acceptable and no additional transfer mechanisms are required to transfer personal data to that country outside of the EU. From the beginning of EU adequacy approvals, it was recognised that the lack of federal privacy law in the US meant that an adequacy approval for the US was unlikely. However, many years ago, recognising the significant impact on US to EU trade that might arise from obstacles to the flow of personal data between the two nations, a compromise was reached many years ago called Safe Harbour. And that was all fine until 2015 and Max Schrems, who we'll speak a lot about, privacy activist. He's now taken 2 cases to the European Court of Justice, Schrems 1 in 2015 and Schrems 2 in 2020. And the result of these 2 cases is that the European Court of Justice held that the underlying US legislative framework, which allows US government agencies to access data held by US organisations, meant that the Safe Harbour framework and its successor, the Privacy Shield, were invalid transfer mechanisms for transfers of data to the US. The EU and the US are trying to reach an agreement on a new framework which addresses the concerns that were raised in the Schrems 2 decision. But in the meantime, the question is how can transfers be validly made under EU GDPR to US-based organisations? EU GDPR has other mechanisms for allowing transfers to countries outside of the EU, not only adequacy approvals, and most commonly used is the mechanism of standard contractual clauses, and this is where the Irish ruling against Meta makes things interesting. Schrems 2 in 2020 centred on Privacy Shield, with the court invalidating the Privacy Shield. But the court also considered the validity of the EU standard contractual clauses as a transfer mechanism. And what it did was it left open the question of whether such a transfer mechanism combined with supplementary measures could enable valid transfers to the US. And this was despite concerns about the impact of US surveillance laws, including the Foreign Intelligence Surveillance Act, FISA. So that brings us to the recent ruling by the Irish Data Protection Commission against Meta Platforms and Meta Platforms Ireland Limited, which I'll call Meta for short. So this ruling by the Irish Data Protection Commission, which I'll refer to as DPC for short, it originated from a complaint by Max Schrems. Surprise, surprise. On the 22nd of May, the DPC published its ruling into its inquiry into Meta, examining the basis on which Meta transfers personal data from the EU to the US for the delivery of its Facebook service. In short, the DPC ruled that Meta infringed the personal data transfer restrictions in EU GDPR when it transferred data from the EU to the US using the mechanism of the EU standard contractual clauses. The DPC reviewed Meta standard contractual clauses, including the updated standard contractual clauses that were adopted by the European Commission in 2021, and all the supplementary measures and safeguards that Meta put in place. The DPC found that these arrangements did not address the risks to the fundamental rights and freedoms of data subjects that were identified by the court in the judgment in Schrems 2. And in Schrems 2, the court held that the requirements of US domestic law, in particular the surveillance and national security programs, they result in limitations on the protection of personal data, which means that they don't ensure an essentially equivalent level of protection as provided in the EU. So, interestingly, some of the measures that were considered but actually deemed insufficient by the DPC were things like organisational measures such as Meta's policies, procedures and oversight requirements, technical measures such as in-transit encryption and access controls, and a further one being legal measures such as contractual rights provided to data subjects and the requirement to challenge US government requests it believes are unlawful. So quite interesting that you would think that many of those things would be sufficient, but in this case they were deemed to be insufficient. So the DPC's decision includes 3 orders against Meta. So that's where we get to the juicy bit. So the first one is a stop order for future transfers of EU user data to the US. And that's to take effect 12 weeks from the date of exhaustion of any appeals by Meta. The second one being the €1.2 billion fine. And the third being an order to bring existing transfers of EU user data to the US into compliance with EU GDPR within 6 months. So that means transfers that have already taken place. Interestingly, the latter 2 orders were not actually in the original decision of the DPC. It was the supervisory authorities in France, Germany, Austria and Spain that objected to the lack of fine. And similarly, the original DPC decision didn't look back, only forward. But the supervisory authorities in France and in Germany objected to lack of an order which would remedy defects with existing transfers. Now, the €1.2 billion fine, this is the largest GDPR penalty to date. Although Meta have actually paid a larger fine for privacy infringements when it was ordered by the US Federal Trade Commission to pay $5 billion US dollars in 2019. So the fine from the DPC is not exactly pocket change, but Meta has had worse. The DPC decision made 4 key observations on US laws. So the first is that US laws do not provide a level of protection that's essentially equivalent to that provided by EU law. No surprise there. The second is that neither the 2010 standard contractual clauses nor the 2021 standard contractual clauses can compensate for inadequate protection provided by US law. And the third is that the supplemental measures and safeguards used by Meta, for which provision is made in standard contractual clauses, they allow for supplemental measures and safeguards, but they did not compensate for the inadequate protection provided by US law. And the fourth being, it's not open to Meta to rely on any of the derogations provided for in EU GDPR when making data transfers. So Meta had standard contractual clauses in place. It had them updated to the most recent version from 2021. It carried out a transfer impact assessment and it put in place supplementary measures. But notwithstanding all of this, the conclusion of the DPC was that it was not enough. So what does that mean for Meta? What do they do now? So the idea of Meta being stopped from transferring personal data of EU citizens from the EU to the US would have a significant impact on their business model. Meta Ireland have said that the stop transfer order would actually require Meta to stop providing Facebook services in the EU, where 10% of their global ad revenue is generated. And what they said is that that hit would significantly surpass the EU GDPR's upper limit of fines for this type of breach at 4% of worldwide revenue. So a big impact. Whether or not Meta will have to stop transferring data to the US will depend on two things: a successful conclusion to the EU to US negotiations for a replacement for Privacy Shield, and how long the appeals process can be dragged out by Meta. So while the appeals process is ongoing, Meta will continue to make transfers under its current framework, and they're unlikely to take steps to make the existing transfers compliant. So, because indeed there's a question of what can Meta actually do to make such power transfers compliant? What does this mean actually for other parties? So although the DPC held that Meta couldn't take a risk-based approach, the decision does leave scope for others to do this. And the DPC decision did acknowledge the broader impact of its decision. The DPC noted specifically that the analysis in its decision exposes the situation whereby any internet platform falling within the definition of an electronic communications service provider, subject to this particular law, FISA 702, PRISM programme, they may equally fulfil of the requirements in the EU GDPR on international transfers or their transfers of personal data to the US. So the FISA 702 legislation provides US law enforcement agencies with far-reaching access rights to data of electronic communications service providers. And this is where the problem lies, because guidance suggests that there are really no measures that can be put in place to allow transfers to such organisations unless you put the data beyond reach of that organisation, which doesn't really help if you actually want the organisation to be able to use, you to be able to access and use the data. So transferring personal data to the US is more complex than simply identifying a valid transfer mechanism. For US transfers, it does remain the case that, notwithstanding that standard contractual clauses are put in place, the transfer, you do a transfer impact assessment and further measures are put in place. You have to do these things, all of those things, if you have any chance of establishing a legal basis under EU GDPR for making such transfers to the US. But it's very much a case-by-case basis. So the question really then is whether the new EU-US arrangements, the Transatlantic Data Privacy Framework, would change this position. So what is the Transatlantic Data Privacy Framework? Also, why didn't they give it a shorter, snappier name, like, I don't know, Privacy Shield 2 or something? But the first question I can answer, the second one I can't. In March 2022, the European Commission and the US reached an agreement in principle for the Transatlantic Data Privacy Framework. And this is to replace the previous framework known as Privacy Shield, which I've mentioned, and which was invalidated by the decision of Schrems 2. So since Schrems 2, there have obviously been moves to try and agree a suitable replacement for that, which actually addresses the concerns raised in the decision of Schrems 2. And the Transatlantic Data Privacy Framework paves the way for a possible adequacy decision by the European Commission. And if adequacy is granted, organisations subject to EU GDPR will be able to rely on that to transfer data to the US. Therefore, no more transfer impact assessments or standard contractual clauses. So, I mean, yes, brilliant, amazing, I hear you say, particularly in light of the recent Meta decision. So, when is this wonderful framework going to be in force? Well, steps have been taken by both the EU and the US, with the EU Justice Chief saying at the end of May the necessary steps on the US side were well advanced. There have been changes to US law to address some of the perceived defects around data subjects' rights, and in anticipation of approval of the framework by the EU Commission, changes to US law were actually made by an executive order and Department of Justice regulations in December last year. But there is still more to be done on the US side. The EU side still has some procedural steps left to take to adopt the framework. It's still going through the approval process on the EU side, and it is not all plain sailing. One of the causes was the European Parliament voted at the end of May to adopt a non-binding opinion rejecting the proposed framework. So the members of the European Parliament that voted against it did recognise that the new framework is an improvement over its predecessors, but it still suffers from significant problems. And what they want is they want something that will provide certainty and something that essentially Max Schrems cannot challenge. So Max Schrems had already said that if this framework is approved, he will look to challenge it. So this is the concern around making sure actually that to give businesses certainty, there's something in place that cannot actually be challenged. In terms of timing, the European Commission issued a statement following the Mesh decision to say it expects adequacy and the transatlantic data privacy framework to be fully functional by the summer. I guess it depends on what your definition of summer is. My understanding is it could be finalised by July at the earliest, but I think it will be later. And I will now pass over to Joe.
Excellent, thanks Ashley. I'm Joe Fitzgibbon. I'm a senior associate in the media and technology team, and today I'm going to chat about some of the privacy considerations relating to the development and implementation of AI. So what are we actually talking about when we refer to AI? Well, as is commonly the case these days, I asked everybody's favourite chatbot, which reliably told me that AI stands for artificial intelligence, and that refers to the simulation of human intelligence in machines that are programmed to perform tasks that typically require human intelligence. So far, so good. So what is AI actually being used for? Well, many of us will be familiar with the unavoidable publicity AI technologies have had in recent months. Some of those examples, of course, include chatbots, which are systems that simulate human conversations, often in the question and answer format. Image and video generators, systems that generate images and videos based on a series of prompts that you give them. And voice clones, systems that generate speech and voice sounds on your behalf. A little closer to home, many of us will already be using AI in our day-to-day lives, from drafting on an automated basis to e-discovery tools. AI is also being widely used by businesses to increase productivity and resource allocation. Some obvious examples of that include warehouse owners using AI solutions to assist workers find products quickly and efficiently. And of course, event organisers using AI to match staffing levels with ticket sales in any particular day. So it's important to remember that while some of these high-profile AI uses get most of the headlines, the general data protection principles that I'll discuss today apply to every instance of AI integration, not just these headline cases. So why is data so important in these systems? Well, it may be obvious, but data is essential for the training and the fine-tuning of these AI models. Some of those require especially large data sets in order to be trained. To give you a feel for the scale of this data use, OpenAI's ChatGPT was built on a model that was trained on over 45 terabytes of data that was scraped from the internet. That included entries from Wikipedia and a corpora of digitalized books. For a bit of context, 1 terabyte is enough to store 6.5 million document pages, so 45 terabytes is quite a lot of information. Similarly to this, another one of OpenAI's GPT models, GPT-3, was trained on approximately 3 billion tokens or pieces of words that were scraped from the web. That included over 175 billion parameters, which are variables that influence the properties and training of the resulting models. So of course, we're talking about a huge amount of data here. Of course, not all of this is personal data. However, some of it is, and also alongside that, many users of these AI systems input their own personal data into the publicly available versions of these models. So data protection considerations are, of course, front and center. So all of this data usage has naturally given some data protection regulators food for thought. Many of you will be familiar with Italy being the first country to take aim at OpenAI for its improper use or perceived improper use of personal information. The Italian Data Protection Authority issued a temporary ban preventing OpenAI from using Italian users' data. After agreeing to certain changes, such as allowing users to submit removal requests for personal data under the EU's General Data Protection Regulation, OpenAI was able to restore its services to users in Italy. I'm sure there'll be other instances of regulators probing these systems to ensure they protect individuals, so it'll be very much a case of watch this space. In terms of regulation in the UK regulator, the Information Commissioner's Office, has released a comprehensive guide on AI and data protection. It's important to note that this is not statutory code, but it gives a really good indication of how data protection laws should influence your approach to AI. The ICO proposes that organisations take a risk-based approach to using AI. And quite simply, this means assessing the risks to the rights and freedoms of individuals that may arise as you use AI. And it also means implementing appropriate and proportionate technical and organisational measures to mitigate those risks. This, of course, does not mean that you can simply ignore the law if the risks are low, but it means you have to have it does mean you have to stop a planned AI project if you cannot sufficiently mitigate those risks. Within this guidance, the ICO has made it very clear that in the vast majority of cases, the use of AI will involve a type of processing that is likely to result in a high risk to the rights and freedoms of individuals. And it will therefore trigger the legal requirement for you to undertake a data protection impact assessment. And I'll say more about that shortly. Given the ICO's view that much of AI will be high risk from a data protection perspective, the guidance is highly relevant to most users and the developers of AI systems. To ensure its practical application, each section of the ICO's guidance discusses what organisations must do to comply with data protection law, and also what they should do as good practice. This is an extremely helpful approach. So what privacy considerations do you need to think about when using AI? Well, I've already mentioned the biggest one, which is data protection impact assessment. And as I said, in the vast majority of cases, using AI will involve processing that is likely to result in a high risk to the rights and freedoms of individuals. Your DPIA should therefore document how you will collect, use, and store the data, the volume of the data and variety and sensitivity of that data, the nature of your relationship with the individuals, and the intended outcomes for individuals or wider society. Your DPI should show evidence, ideally, of why the intended use of AI is less risky than other alternatives, and the ultimate aim of your DPIA is to demonstrate that it's necessary and proportionate to use the AI. A key aspect of this analysis in a DPIA is aimed at ensuring fairness of the outcomes of the AI systems that you're going to use. In simple terms, fairness means that you should only process personal data in a way that people would reasonably expect and not use it in a way that could have unjustified adverse effects on them. You should not process personal data in ways that are unduly detrimental, unexpected, or misleading to the individuals concerned. And the ICO's guidance provides very detailed guidance on fairness and how this should affect the implementation of the AI that you use. More general considerations is of course selecting a third party that is suitable to provide AI services to you if you're not developing them yourselves. If you are procuring AI services or products from a third party, you'll need to go through the usual audit and approval that you do for any technology provider. As you'd expect, an AI provider will be a data processor and should carry out the same diligence you would in appointing any data processor. Part of this, of course, involves identifying international transfers, which Ashley has covered in a lot of detail, particularly with the US focus. But in many cases, you will be transferring data outside of the UK or the EEA. So you'll need to make sure your contract with any AI service provider incorporates the SCCs or the UK IDTA into the agreement with that processor. Sitting alongside this, the SCCs and IDTA, you should also carry out a transfer impact assessment in order to identify any specific risks associated with the transfer and how you'll mitigate those risks. And transparency. This is one of the fundamental principles within the GDPR, and you'll need to make sure that you have the right to use the data for the purpose envisaged by your use of AI. You'll therefore need to make sure that your privacy notices inform data subjects that you might use their personal data and the purpose and the applicable legal basis for this use. As many of you will note, the ICO's guidance on AI places a very strict and is very encouraging in the fact you should describe the AI in very basic terms and precisely how it is used to make decisions and how those will impact the individuals affected by it. Alongside this transparency obligation, you should check the terms and conditions associated with your AI provider service. Do they, for example, permit reuse by that company or in order to train its own AI models? If there's an option, for example, to use a paid-for integration, this might be something you can avoid. For those of you who have looked at integrating OpenAI's paid-for API into products and services, you'll note that the data processing agreement states that the data supplied to OpenAI through that API will not be used to train the underlying model. And this is comfort that I'm sure many of your customers or service users may wish to be aware of. And sitting alongside this, you should also make sure that you're conducting internal training to ensure that your own staff are aware of the parameters that you set around using AI solutions. For example, making sure that personal data isn't uploaded if it's not appropriate, and also setting controls on who can access the systems involved. So in conclusion, AI will almost certainly trigger the requirement for DPIA, and I'd strongly suggest you read the ICO's very helpful guidance when it comes to that implementation. It's very practical and is ultimately aimed at ensuring the fair deployment and development of AI. And if you're having any difficulties getting around any of the key risks that your DPIA identifies, you should take that time to engage with the ICO. They're very keen to assist with developers and users of AI generally. So they'll be able to help you navigate any risks that you associate or identify as part of your implementation process. So that's a whistle-stop tour on AI. I'm now going to hand over to Carly.
Thanks very much, Joe. Hi, everyone. I'm Carly Duckett, and I'm a solicitor in the Commercial Disputes team here at Shepherd and Wedderburn. Recently, in our team, we've seen an increase in queries from clients across all sectors about compensation claims for alleged breaches of data protection legislation. And some of those claims have been well-founded, but a lot of them were speculative. And even where there has been a breach, the amount claimed tends to be excessive, which might sound familiar to a lot of you. The increase in these claims is probably partly due to the press coverage around the GDPR. There have been some really high-profile data breaches, and the subsequent fines that have been imposed by the ICO have been widely publicised. So the general public is now far more aware of their rights when it comes to their data. As a result, we've seen data breach claims becoming a real focus for claims management companies who are able to process a high volume of that type of claim with relative ease and at a relatively low cost. The law on claims for damages arising from GDPR breaches is reasonably settled now in the UK, but to give a brief recap, the right to claim compensation for any damage that's caused by a breach of data protection legislation is set out in sections 168 and 169 of the Data Protection Act 2018, and this is completely separate from the powers that the ICO has to issue fines. These claims can be for material damage, which is actual financial loss, or non-material damage, like distress, for example. And for that reason, you'll often hear people refer to these types of claims as damage and distress claims. The most high-profile judgment on this type of claim is one that you might be aware of already. It's Lloyd against Google, and that was a class action in which the Supreme Court decided that a loss of control of your personal data did not entitle you to claim compensation. The Supreme Court also decided that the compensation would only be payable if the person had actually suffered damage, and the damage shouldn't be trivial. Given the types of sums that are typically claimed in these types of cases, and in Lloyd it was £750 per person, it's often disproportionate for the claimant to pursue the claims because the damage has to be proven on a case-by-case basis. In our experience, firms pursuing compensation for data breaches tend to send a standard form communication, so a letter that requests a nominal sum of money on their client's behalf following a data breach. And while some claimants instruct firms to send a letter to the company in breach to request compensation, which, as I say, can be done at relatively low cost, in the hope that the company pays them something, it's often worth bearing in mind that sometimes data breaches can actually cause individuals loss or distress. An example of that is the TLT against Home Office case in which asylum and leave to remain applicants' personal data was wrongly published online. That caused them obvious distress, and they were awarded between £2,500 to £12,500 each. Recently, there have been a number of cases relating to damage and distress claims, so I'm going to take some time now to talk you through the court's decisions in cases that helpfully illustrate the types of claims in which the courts are likely to award damages. The first of those is Ali against Chief Constable of Bedfordshire, which was decided earlier this year. If you're not familiar with this case already, the factual background to the Ali case is actually quite interesting. Mrs. Ali's ex-husband was a drug dealer, and she had contacted the police to inform them that he had been dealing cocaine and she thought that he could be a threat to her family. When she made that report, she repeatedly and emphatically told the police that she didn't want to be identified in any documents that related to her report to them. And they reassured her at that time that she wouldn't be so identified in their documentation. The police then sent that information on to a local social services unit, which they did without anonymising her personal data as they'd promised, which included her name. Unfortunately, an employee of that social services unit called Miss Begum was in a relationship with Miss Ali's ex-husband at the time. She found the report and gave a copy of it to him. And it wasn't only that report that Miss Begum had access to, she had also accessed 10 reports that related to Miss Ali, 3 of which contained highly sensitive data that could have put her family at risk. When Miss Ali found out what had happened, she became extremely distressed, suicidal, and asked to be rehoused. When the claim went to court, the police couldn't demonstrate that it was necessary for them to disclose Miss Ali's name when they were sharing the information with social services. And it followed that they had breached the GDPR. Interestingly, the court commented that even if the police had established that disclosure of her name was necessary, the police would still have been in breach of the GDPR because they didn't inform her that they had passed on her information to social services. Miss Ali was awarded £3,000 for the distress and anxiety that was caused by the police's breach. As an aside, Miss Ali raised a separate action against the relevant council in relation to Miss Begum's accessing the reports, but that was a vicarious liability claim which starts to stray beyond what we're talking about today. So to take us back to GDPR damages and distress claims, another higher profile case was Driver against Crown Prosecution Service, which is a case from last year. And it was a lower value claim than Ali, but also an interesting set of circumstances. Jeff Driver is a relatively well-known local council leader in Lancashire, and he's been a suspect in police investigations into various offences for quite a few years now. And in 2017, he was arrested with 3 others on suspicion of conspiring to pervert the course of justice. And this became public knowledge at the time. It was in the press, and you can still find press articles about it online today. In 2019, a member of the public who reportedly had a grievance against Mr. Driver requested an update on the investigation into his conduct. The CPS responded and confirmed that a charging file had been referred to the CPS for consideration. They didn't name Mr. Driver in their email. The recipient then sent the email to other third parties, which included Mr. Driver's political opponents and journalists. And Mr. Driver claimed that the CPS's email amounted to, among other things, unlawful processing of his personal data, which had caused him significant distress. He sought £2,000 in damages. In support of his claim that the breach had caused him anxiety, Mr. Driver relied on the fact that he had visited the doctor with anxiety symptoms and was prescribed anti-anxiety medication at the time. In this case, the court held that the CPS's actions did amount to unlawful processing of his private data, even though he wasn't named, because he was still directly identifiable in the email chain. The judge didn't think that there was enough evidence to show that the data breach itself was the specific cause of the anxiety that Mr. Driver experienced, though, and that the distress associated with the breach would have been modest, so he was only awarded £250. Notwithstanding the low sum awarded in that case, I think taken together, these cases highlight the fact that claimants must have actually suffered distress or damage to succeed in any claims for compensation for GDPR breaches. And now that we've spoken about 2 claims where damages were awarded, I thought it might be helpful to talk about a case where damages were not awarded. And in that case, they weren't awarded because if any damage or distress was suffered, it was held to be below the de minimis threshold. There wasn't actually very much guidance on this before 2021, but there's a case, Rolf against Veal Waspra Vizard LLP, in which the courts clarified what the de minimis threshold would be for these types of claims. In Rolf, the claimants sought compensation for distress because a law firm had mistakenly sent an email that was intended for the claimants to somebody else. This was as a result of a typo in the email address, in the email. It was just an incorrect character in the email, which ended up going to the wrong person, which you can imagine could happen quite easily. For example, if you've misspelled somebody's surname and used Mac instead of Mick or something like that in Scotland. The email and its attachments demanded that the claimant make payment of school fees, and the email had the claimant's names, home address, a statement of the school fees account, and a reference to the fact that legal action might be taken if the debt wasn't paid. It didn't contain any of the claimant's financial information though, so no bank details or credit or debit card details. As a result of this, the claimant said that they had suffered distress and sought compensation. The alleged distress was associated with the loss of control of their data by the claimants, and they wanted compensation for the time that they had spent dealing with the matter, which is actually something we hear quite often. They claimed to have lost sleep over it and felt physically ill with worry. The defendant had dealt with this quite well though, and they had become aware of the incident fairly quickly. They immediately asked the unintended recipient, who was not known to the claimants, to delete the email. The recipient did so and confirmed that they had done so. And the email was also encrypted, so only those with access to the associated email account could have seen it. On that basis, the defendant applied for summary judgment on the ground that the breach couldn't have caused damage or distress above the de minimis threshold. In this case, the judge agreed and dismissed the claim, stating that the alleged distress was plainly exaggerated, inherently implausible, and didn't meet the threshold. You can tell from those brief quotes that the judgment is actually quite scathing, and it notes that in this day and age, claims for frankly trivial breaches, in the judge's own words, are not appropriate, where no person of ordinary fortitude would reasonably have suffered the distress that was alleged by the claimants in these circumstances. It's also worth noting that the costs of the case were awarded against the claimants on an indemnity basis to reflect the speculative nature of the claim. There are another couple of cases that are helpful for potential defendants that I'm now going to talk about. They are Johnson against Eastlight Community Homes and Stadler against Curry's Group Limited, both of which touch on proportionality and cost. I'm conscious of our time today, so I'm not going to go into the details of these cases, but they convey a very similar message on proportionality. Both claimants raised their actions in the High Court and were seeking relatively low damages. Johnson was only seeking £3,000, and the courts were critical of the claimant's approach in both cases. Johnson had raised her action in the High Court, incurred £15,000 to get to the hearing, and estimated the cost of the case to be £50,000 against a claim value of £3,000. The judge ordered that that claim should be reallocated to the small claims track. And similarly in Stadler, the judge recommended that the claim should be reallocated to small claims because it wasn't suitable for the High Court. And that was because the cost would not be proportionate to the potential award that was sought. We have seen claims where even at the pre-action stage, the legal costs that are said to have been incurred are more than triple the damages claimed. And there's a real issue around proportionality that can then make them very difficult to settle. So in practical terms, when the claim is in the hundreds or low thousands of pounds and where recovery of legal costs is capped, it will be difficult to bring the claim in a cost-effective way. Those recent decisions that we've talked through this morning indicate that the courts are alive to the practical issues that these claims present and that they are attempting to take a pragmatic approach, which is helpful. They're also a warning for anyone contemplating a claim for distress, because the courts will take action to sanction a claimant who brings a claim that lacks real substance. So some of the key points to keep in mind and take away from this are, firstly, that it's really important to consider the possible consequences of a breach at the outset. If a breach can be identified quickly and reasonable steps are taken to manage the impact, it helps maintain a positive dialogue with the data subject, which reduces the risk of a claim. And if one is raised, it can help you because it gives you better arguments that the loss suffered is trivial. If a claim is made, you should think about whether there has been a breach and whether you have any additional reporting obligations. Thirdly, whilst the current trend is toward largely speculative claims, it's important to try to be objective. While you might get some chancers, some people could genuinely suffer loss and or distress. So if you review the claim and you think that the claimant can identify a financial loss, or if there are good reasons to support a claim for distress, it can be better to try and agree an early settlement of the claim, or to at least make an offer so that you can try and protect yourself against the potential cost consequences if it is taken any further. And finally, if you review the claim and it seems speculative, the recent cases that we've discussed give you examples of strong preliminary challenges that can be raised at a pre-action stage. These challenges can often put the potential claimant off bringing the claim, which is also helpful. These types of claims will continue to be raised as we move forward, and we'll see more patterns emerging in how the courts deal with them as time goes on. But the recent decisions indicate a common sense approach is being taken, which should be reassuring for potential defendants. And with that, I'll pass back to Joanna.
Thank you very much indeed, Carly. For those who weren't here at the very beginning, I introduced myself then, I'll introduce myself again. My name's Joanna Bogue-Thompson. I'm one of the partners in the Media and Technology team at Shepherd and Wedderburn. And I am going to talk to you about some of the developments and activities at the ICO, the Information Commissioner's Office, over the last 6 months or so. So I'm going to start the update with a mention of the Children's Code. And when we did our webinar in November, we talked about the Children's Code, but there are a couple of developments that I want to pick up on. So the ICO Children's Code, or to use its formal title, the Age Appropriate Design, a Code of Practice for Online Services, has actually been in force since 2021. And at the time, it was recognised as leading the way in terms of looking at how to address particular concerns regarding the interaction of under 18s with information society services. And since then, we've seen similar developments in other countries, notably, for example, California and other US states, and developments in Europe on children. So the Children's Code sets out a set of 15 flexible standards that are designed to ensure that the best interests of the child are the main consideration for those designing and developing online services. And one of the key questions for designers and developers is when this code actually applies. And where under 18s are the target market, obviously there's no question about whether or not the code should apply. And by logical extension, it would seem that you should be able to argue that those targeting the over 18s wouldn't actually need to address the code's requirements. However, we're all aware of access by under 18s to inappropriate material or material that's not aimed at them. And so it's not enough for businesses simply to say who their target market is and just to pay lip service to age restrictions. And for that reason, the ICO is currently consulting, or has just finished its consulting period, on draft guidance on the application of the Children's Code in some cases. And so last year, the ICO confirmed that adult-only services would be in scope of the Children's Code if they are, quotes, likely to be accessed by children. And in the view of the ICO, the determinant factor is whether those services are likely to be accessed by a significant number of children, again in quotes. And how that's determined is absolutely key for online service providers. And that's what the ICO is seeking to address in its draft guidance. So the ICO put out its draft guidance some time ago, and the consultation closed on the 19th of May. So we wait to see what happens with the guidance. But businesses offering online services now need to build a Children's Code assessment into their accountability requirements. So you heard Joe talking about the need for a DPIA for AI applications, and this is another form of accountability for Children's Code assessments. And the draft guidance that the ICO issued is aimed at helping organisations to make that preliminary assessment in cases which are not clear. And it does that by looking at whether or not the online service they're offering is likely to be accessed by under 18s and how that can be assessed. And it's not enough to simply put age verification requirements on a site, because these can often be easily overcome. And I suspect many of us have watched our children doing exactly that. And if you decide that the Children's Code does not apply, then that decision has to be documented. Now, the examples in the draft guidance were drawn from 3 areas: pornography, gaming, and social media. And while these are important areas, it would actually have been useful to have had some wider examples around areas that are perhaps a little more grey. So hopefully that's something that might be taken into account following the response to the consultation when the final guidance is issued, or else as practice in the area develops. So for something like pornography, it's clear that the material is deliberately targeted at the over 18 market. So the real question there is about how to address age verification and making sure those verification measures are robust. And for other areas, such as gaming and social media platforms, they might also choose robust age verification, But in all cases, it's absolutely key to be able to demonstrate that the children's code has been addressed and has not been ignored. So as I said, this is a part of the accountability requirement under GDPR. So as I said, the consultation on the new guidance closed in May, and we're waiting for a finalised version, but I think we can very clearly see the direction of travel in this area. The next element I wanted to cover was fines. I'm not going to talk a lot about fines because there's been a lot of press coverage given to the fact that the relatively new Information Commissioner, John Edwards, has changed the approach of the ICO, and he's seeking to engage with the ICO's customer base and promote compliance rather than being seen as simply an enforcer. And there's a relatively small number of fines issued by the ICO compared to European regulators. And you've heard Ashley talking about the Irish Data Protection Commission and Meta, for example. However, the ICO did impose a pretty chunky fine on TikTok in April this year. And that was a fine of £12.7 million for misusing children's data. Now, the UK GDPR says that parental consent is required for under 13s to obtain access to services like TikTok. And so this leads to TikTok and others clearly prohibiting use by under 13s because obtaining parental consent adds a further layer of complication that they don't want to have to engage with. However, this only works where there's robust age verification in place. And in this case, the view was that TikTok didn't have such robust measures in place, and nor did it review its services to remove under 13s once they'd been identified. Still on fines, live marketing calls continue to attract fines. So for example, last month, the ICO issued a fine of 180,000 for 2 companies that made more than 480,000 unlawful marketing calls to businesses that were signed up with the UK's Do Not Call register. So that's still a fertile area for fines. But what the ICO has turned to doing more and more is issuing reprimands. And a reprimand is made publicly. So clearly a reprimand can lead to reputational issues for the organisation that receives the reprimand. And so quite recently, the Ministry of Justice was issued with a severe reprimand from the ICO. And that was because confidential waste documents were left in an unsecured prison holding area, and they were awaiting shredding uplift, and they hadn't been uplifted. So prisoners and staff had access to 14 bags of confidential documents, which included medical and security vetting details, and they had that access for a period of 18 days. And astonishingly, during this time, staff challenged prisoners who were openly reading the documents, but did nothing proactive to ensure the personal information was secured. And so at least 44 people had access to the information while it sat in the holding area. So not a great example for the Ministry of Justice to be setting. There's been some new guidance issued by the ICO on subject access request. I'll refer to them as SARS. And that SARS guidance is issued for employers, and it was issued at the end of May. And there were over 15,000 subject access complaints to the ICO last year. And the ICO has said that they're concerned about failures by employers to respond to subject access requests by employees. So the ICO says that many employers are misunderstanding the nature of subject access requests or underestimating the importance of responding to requests. And they say, for example, employers might be unaware that requests can be submitted informally, such as over social media, or don't have to contain the words subject access request in order to qualify as a legally binding request. So I had to read through the guidance, and I have to say it's very useful. It's got a lot of examples in it, and I would commend it to you as something to become familiar with. What I would say, however, and this is very often the case, the ICO's guidance does tend to favour the person making the request. But it deals with a number of really difficult issues. For example, the interaction of a grievance or a tribunal or a claim alongside a subject access request. So I would strongly suggest you read that guidance. It's very helpful. Moving on to legal reform. So In November, we were talking about the Data Protection and Digital Information Bill, and we were wondering what was happening with all of the changes in government. And so a new version of it was laid in Parliament on the 8th of March. So the UK data protection reform process is now clearly back in play. And so rather than going through all of the changes that the bill will make to data protection, which we dealt with last time, I'm going to talk about the changes between the old bill and the new bill, because some of these are really quite interesting. The first and probably the most significant change is the clarification that's been added regarding legitimate interests. So recital 47 of the GDPR has always contained the clarification that the processing of personal data for direct marketing purposes may be regarded as carried out for a legitimate interest. So when we give advice on marketing, we talk about compliance with the PECR regulations, which are a different set of regulations, and we normally suggest that the marketing under the GDPR obligation is done on the basis of legitimate interests. And the new bill adds a non-exhaustive list of scenarios where organisations can rely on legitimate interests, lawful basis, including for the purposes of direct marketing, or transferring data within an organisation for administrative purposes, or ensuring the security of network and information systems. So that's very helpful, but it's important to note that the necessity and balancing tests will still need to be met for legitimate interests. And the explanatory notes do something else that's quite helpful. They clarify that controllers can rely on legitimate interest to process personal data for other legitimate activities if the process is necessary and the balancing test is carried out. And this seems to be an indication that controllers can consider other legitimate commercial activities as being within their legitimate interests. And it looks likely that this has been added to try to avoid the uncertainty that exists at the moment in the EU. And that uncertainty is about whether purely commercial interests can be legitimate interests. And in the last webinar, I talked about a Dutch case where there's a suggestion that commercial interests cannot be legitimate interests. So in the UK, when this reform goes through, if this reform goes through, we'll have some more clarity on that. A little bit on research under the new bill. So some elements have been moved from GDPR recitals into primary legislation, and the new bill retains the non-exhaustive list of scientific research types. And those are applied or fundamental research or innovative research into technological development. But it also adds some firmer language confirming that research can constitute scientific research, whether it's carried out as a commercial or non-commercial activity. So the commercial activity is important, obviously for our pharmaceutical industry, but I think this is going to cause a level of debate as the bill progresses. On records of processing activities under the new bill, the record keeping requirement now only bites when personal data is likely to result in a high risk to the rights and freedoms of individuals where the processing is high risk. And so that's likely to be of benefit to UK SMEs who don't have establishments in the EU. If you do have an establishment in the EU, then you'll still be required to have a record of processing. Automated decision making, I'm not going to say very much about this. Joe's already talked about AI, but the new bill has an additional safeguard to ensure that human involvement is effective in practice where it's needed and doesn't continue to amplify existing risks with data-driven decision making. And the final thing in the new bill that I think is helpful is it's very clear that there'll be continuing recognition of the existing safeguards for international data transfers. So they'll still be lawful once the new bill becomes law and takes effect. So that includes the UK's addendum to the EU standard contractual clauses and the UK's international data transfer agreement. Ashley talked about transfers from the EU to the US, and Ashley, you mentioned that there's no snappy title. I think it's worthwhile saying that a week ago, Rishi Sunak and President Biden announced that they've committed in principle to establish a data bridge, allowing for the free flow of data between organisations in the United Kingdom and participating organisations in the United States. So I think that'll be something similar to the old Privacy Shield. It is worth mentioning that if you don't already have your international transfer agreements in place, you need to be moving ahead with that to to meet the March 2024 deadline for transfers from the UK. And of course, you should already have done that by the 27th of December 2022 for transfers from the EEA. So we're close to time. That's a brief roundup of some of the ICO's key activities in the last few months, and we'll bring today's webinar to a close. I hope you found the update useful. If we can help with anything, please just get in touch with one of the speakers from today or any other member of the Shepherd and Wedderburn data protection team. Thank you very much. Have a good day. Goodbye.